Well, good afternoon. Thank you for joining us for our statewide webinar. This one is legal options for parents when an ARD was not enough. So we're going to talk about dispute resolution options with Colleen Elbe from Disability Rights. Before we get started, just a little bit about us. Partners Resource Network is the nonprofit agency that operates the Parent Training and Information Centers for Texas. And we have the PATH Project, the PEN Project, and the TEAM Project. We are federally funded from a grant from Department of Education, Office of Special Education Programs, known as OSEP. We provide training, education, information, and referrals, technical assistance, and emotional support for parents of children with disabilities birth to 26 years of age. So I want to welcome Miss Colleen Elbe, and as soon as she is ready, we can get started. Real quick, Colleen, before you get started though, we are doing live Q&A today. So if you don't mind opening up that Q&A box at the bottom of your screen or possibly at the top and entering in any questions that you have there so that we don't lose the questions in the chat box. Also, we are recording this presentation and it will be available on our website probably, I guess, tomorrow or within like the next couple of days. So Colleen, you are welcome to get started whenever you're ready.
Great. Thank you, Megan. Hopefully everybody has heard about Disability Rights Texas. Just in case you haven't, we are the protection and advocacy system for the entire state of Texas. We are federally mandated to protect and advocate for people with disabilities across the whole state in a bunch of different areas, but obviously specifically we're going to be talking today about educational issues. I am a senior attorney on the education team. I'm out of our Lubbock office. So all of my cases have some basis in education, and I work cases about inclusion issues, transition issues, restraint and seclusion, pretty much lots of different issues across the public school systems and across the state. I've been with DRTX for about 13 years now, and I encourage you, if you want to learn more about the agency, more about the work we do, go to our website. That's here on that first slide, www.drtx.org. I typically like to thank Megan and Christina for allowing me the option to do these great webinars and get information out to parents, but I've kind of noticed a trend. The first time I did this, it was about issues with bullying. That's a frustrating and stressful topic. Now it's a topic about what to do when you disagree with a school district, another frustrating and stressful topic. And we're in discussions to do another webinar training about services and options after your kid with disabilities turns 18, which of course is a very stressful topic for parents. So I get assigned these stressful and frustrating topics, but this one's kind of different because it shouldn't be as stressful or frustrating as it sounds. Parents actually do have lots of options, even if there's a disagreement at an ARD committee. So we'll walk through some of those, and hopefully at the end of the presentation, you feel a little bit more empowered and knowledgeable about what some of those options are and can choose an option that works best for your situation. So let me make sure I can figure out how to advance the slides here. Let me see. Christina, you might have to help me. Oh, there we go. Okay. I don't know what worked. It just magically advanced. So before we take a look at the options that you have after a disagreement, I guess maybe the logical place to start is how to avoid a disagreement in the first place. I know that there has been some training on this issue before, so we'll just briefly touch on this topic before we get started into some of the other legal options for parents. But basically, the best way to avoid disagreement is to work off of updated data. That data can come from evaluations and assessments. That data could come from observations, outside providers. I am a data queen, and I'll tell you why. If I am in an ARD and I personally am disagreeing with a principal, an occupational therapist, a speech therapist, a teacher, an aide. It doesn't matter. We can go back and forth and disagree with each other all day long and have the longest ARD, most contentious ARD known in history. But you cannot argue with facts. You cannot argue with data. And one of the most powerful things is to use a school district's data against them. So, for example, if the district is proposing a more restrictive placement for a student, and they say, you know what, sorry, little Sally, she can't handle 45 minutes a day of inclusion. What is the data telling us? Are they keeping track of how long she's being included in the general education class? What happens at minute 23 to 25 when she has to be removed and taken to a more restrictive placement? We can talk about she can't handle it, what that means, who defines it as what, but until they start keeping good data on how long she is involved in the general education classroom, what are some of the behaviors that are most difficult for the teachers to appropriately respond to, what supports and services are working or aren't working, it's not going to do any good. We could disagree all day. So if you're in a position where somebody from the school is recommending a service or support be denied or cut in half or severely decreased, or they're not agreeing to do something, don't just take their word for it. Ask to see the data that backs up that decision. And then, of course, get everything in writing. In my world as an attorney, nothing happens unless it's written down. So if somebody from the district denies a particular evaluation, assessment, service, get that denial in writing. And then you can decide what option to take afterwards. If they refuse to do a particular assessment or an evaluation, don't be shy to use your option and request an IEE. We've got a great handout on our website about how to do that, when to do that, why to make that request. But I will tell you, it's good to be, first of all, you have to give the school district the first bite at the apple. If you say your kiddo needs a particular evaluation or assessment, the school gets the first chance to complete that. If that comes back and it's not thorough, it wasn't done by somebody appropriately qualified to do it, then you can ask for an IEE. But I would suggest that if you do that, be specific about why you're requesting it. Don't just say that you didn't like the district's outcome. You have to show that there's some sort of flaw in what the district did or who did that assessment for the district. But again, if IEE is an option for you, go to our website for more information, and hopefully that'll be helpful. The other thing is to keep a copy, your own copy of everything that's written. So every ARD document, every assessment and evaluation, start your own file, keep your own records so that you don't rely on the district to go back and look at something. And then certainly keep records on things that aren't written down. If you have a phone call with a teacher or a principal or an in-person staffing that's not documented in an ARD document, make sure you write that information down and keep that in some type of contact log, because that, again, might be helpful. If you're like me, your memory might not be that good when you're thinking about, when did I talk to Principal Smith about that topic 2 months ago? So keep all of that stuff documented and in a safe place. And then certainly know what your options are, and they're all spelled out in that procedural safeguards handbook. I know that you guys could probably all wallpaper a bathroom with as many as you get in a school year, but that really is your friend, because it will outline all of the requirements for all of these options and more that we'll talk about today. Okay, so and I put on this slide that these are options for any student with a disability, and really that's not, I started thinking about it, and that's not really correct. It should read for any student. The student doesn't have to have a disability to take advantage of these options, and these would be even before a disagreement in an ARD committee meeting. Obviously, any parent or worker that's working with a student that suspects abuse or neglect always has the right and sometimes the mandate to report suspected abuse or neglect to DFPS. Sometimes there are teachers and aides that are suspected of doing terrible things, and those need to be reported. If you think somebody else might have reported it, again, report it yourself just to be sure. That's an option for every student. Another option is that every teacher, every principal, administrator, aide, anybody who's certified by the state of Texas, you can file a complaint on that certification through the State Board for Educator Certification. I've included a frequently asked questions website with more information on that. I think it's kind of frustrating for parents sometimes. I haven't had a lot of those complaints be investigated. And the ones that were investigated, they were pretty egregious complaints. Physical marks left on kids, video footage of teachers, basically physically assaulting a student. So those are, I think they only investigate pretty egregious allegations, but it's certainly any parent's right to file a complaint against an individual through their certification. Now, the good thing about that is that if it is looked into, it's investigated, and the allegation is founded, then the state has lots of options to kind of ding a professional's certification, meaning that even if that professional quits your district and tries to move to another district, that ding on their certificate will follow them. So it's pretty severe, but that website will give you more information on what they'll look into and also what kind of options they have as far as discipline. So I would, if that's something that interests you to learn more about, I would suggest going to that website. Okay, so now let's move into students that are carried under 504 services or should be carried under 504 services. You have the right, if you disagree at a 504 meeting, so we're not quite at the ARD process yet, that you can file a civil rights discrimination complaint with the Office of Civil Rights. That complaint is basically saying that the public school district is discriminating against your student on the basis of their disability. So not because they don't like your kid, not because it's a boy, not because he's tall, it has to be because of a discrimination. My kid has red hair. Sometimes he's discriminated against because of the red hair, but it has to be, the 504 complaint has to be based on discrimination due to the disability. I would suggest in that complaint that you offer enough information because you're trying to convince them to investigate the issue. So obviously put enough information in there that it's specific. You give dates, you give names, you give things that were said, things that were done, things that were not said or not done. Be as specific as possible. I also recommend that you put in there your requested remedies, what you would like to see the Office of Civil Rights do if they find in your favor through the investigation that your child was in fact discriminated against. Make it as easy for them as possible to look into it, to find that your allegation is substantiated, and then to rule in your favor. You're going to be talking about how your child, because of their disability, does not have the same access to, there's not a level playing field. Your child, because of their disability, doesn't have access to the same things that a child without a disability has on that campus in that district. So that's kind of the basis of a 504 complaint. It's pretty time sensitive. There's a 6-month statute of limitations, so be mindful of that. And then the other thing is that it has some interesting interplays with formal grievances that are filed at the district level, which I guess I should have talked about in the last slide, because that's really open to any student. Most districts have a 3-tiered complaint process, meaning that You file your first complaint with the district. If it's denied, you can appeal it to the next level. And then the third level is usually you appealing it to the school board. Well, 504, or the Office of Civil Rights, says that you can't do both at the same time. You cannot have a 504 complaint going as well as a formal grievance at the district. So if you haven't filed either, I suggest you pick which one you want to do first. You don't have to do the local level grievance to do a 504 complaint. You just can't do them both at the same time. So when I give the website for the OCR complaints on the next slide, they'll have much more information on how those two interplay, but I wanted to bring your attention to it because that's not how it is with an IDEA complaint. So just keep that in mind if that's an option for you. And again, keep in mind that there's a short 6-month statute of limitations for 504 complaints. So here's where your 504 complaint would go if this is how you choose to proceed after any type of disagreement at a 504 meeting or any kind of denial of 504 services. Our local OCR office is out of Dallas. So there I provided the website as well as the mailing address and the telephone and fax, as well as the website. And an important thing to note is that there is an anti-retaliation statute built into the law. So if you file a 504 complaint and the district retaliates against you or your student because you filed that complaint, then guess what? You file another 504 complaint based on the retaliation issue. So that's something important to keep in mind because although I hate to think of that happening, I know that it does. Okay, so now let's talk about IDEA eligible students. And when I say IDEA eligible, this would include students that aren't yet identified as a student receiving special education services. So all of these options could cover students where parents have already requested assessments and they're in the process. These options could cover students where the district should have known that they had a disability and were eligible for services. So there's a couple different kiddos that these options kind of cover. Just keep that in the back of your mind. And we're going to kind of talk about these as we move from left to right on the screen. Left being the least adversarial option, meaning that it's kind of the nicest option, the kinder, gentler option. And then we'll move to the right to due process, which is the most adversarial option for parents. Okay, so the first one is the 10-day recess. I think this is probably the most under or misused option for parents. A lot of times we go to ARD, we disagree with the ARD, and then by law we have to come back in 10 days, but nobody really knows what that means. We just know we disagree and we have to come back and disagree again in 10 days. Well, not necessarily. If you formally disagree at an ARD, you can request the reconvening meeting, and that has to be within 10 school days. That's why they call it the 10-day recess. But it's not, I don't take it as a free pass to just think about how much you disagree with the district or why. I like to leave that disagreement ARD where everybody has an assignment. So over these 10 school days, here's what the district's going to be doing, and here's what I'm going to be doing. And then when we reconvene, we update each other with our assignments that we did during that recess. So it's not just that we're coming back to disagree again. Hopefully we're coming back to the table with new information, new data, new ideas, and a new way that we can proceed and hopefully agree. I think this is important for anything, a disagreement about related services, maybe disagreement about behavior. Do 10 school days of pretty thorough observations and data collection. It could be used in transition where maybe you go to an annual ARD and they forgot to invite a TWC counselor, a DARS counselor, and you need the 10-day recess to have that person there. You can use that recess for anything you want, but I really suggest leaving that ARD where you're disagreeing, where everybody knows how they're going to be spending the next 10 days to hopefully get the process going again when you reconvene. The next option, I'm probably not the right person to talk about this option because I've never done it. It is available to parents, the state IEP Facilitation. That's done through TEA. It's a free service for parents. It's a voluntary option. Parents and the school district will have to voluntarily both sign a request form for that. And it's a pretty quick turnaround. It's a 5 calendar day turnaround from the meeting where you disagreed. And basically what TEA does is they provide a facilitator to come to the next ARD meeting and guide the discussion. They could set an agenda, they could set some guide rules, they could ask clarifying questions, just kind of lead the discussion in hopefully a more productive manner than what happened at the disagreement ARD. What's interesting to note here is that the facilitator doesn't have any decision-making powers. They're simply there to just guide the process, move it along, but the ARD committee still retains all of the decision-making power. Again, I've never done this, so I don't know in practice what it looks like. In my practice, when I come to an ARD, there usually already is an agenda. We usually already have identified issues that we want to discuss. I have no problem playing dumb in ARD committee meetings, and if I don't understand something, I ask them to explain it. I ask clarifying questions. I make sure I understand everything and that the parents I represent understand everything. So I don't really know how different it would be having a facilitator compared to all the other ARDs I've been to over the years. But it's certainly an option for parents, especially if there's, I think, some personal stuff going on with the district. You know, sometimes those relationships can get real strained, and you just need somebody else to help you kind of guide you through that conversation. So maybe it would be good in that aspect. So kind of moving down that arrow a little bit more adversarial, because now we move out of the ARD room, if you will, out of the ARD process. The next option is mediation. These are 2 movies that have really cute scenes about mediation, but they're probably scenes about how not to do mediation. The one on the left is a movie called The Breakup with Vince Vaughn and Jennifer Aniston, and it's about a relationship splitting up, and their buddy, who's an attorney, is trying to get them to figure out, you know, who's going to stay in the condo, are they going to sell it, and all that. And then the movie on the right is Wedding Crashers. And they were both attorneys in a mediation session, and it was awful. It was definitely an example of how not to run a mediation. But they're good at kind of signifying the process of mediation. It is a formal process. So again, you're out of the ARD committee meeting, and you're now relying on, again, a neutral party, a mediator, that would be assigned by TEA for free. It's a free option for parents. That mediator would step into that relationship between the disagreeing parties in the ARD meeting and try to facilitate an agreement. This can be filed at any time in the process. You don't necessarily have to have a disagreement ARD before you request mediation. And we'll talk about when it's an option, even as you get more adversarial in the process. But either the district or the parent can request this. It is, again, voluntary. Nobody can make either party do this. There's a form on the TEA website that you can fill out, sign, and submit requesting that. And the reason it's a little bit more formal is that if you reach an agreement in mediation, you draft a settlement agreement. So it's basically a contract between the parties, what the parent agrees to do, what the district agrees to do. If that contract is violated, then you can go to court on a breach of contract claim. That's a little bit more formal than if you go back to ARD, have an IEP facilitator, and you reach an agreement in your next ARD. This is a little bit more formalized, a little bit more adversarial, because it could wind up in a courtroom. Those settlement agreements are binding, they are a contract, and they are enforceable in court. And sometimes with mediation, it's definitely not like an ARD. I've been to mediations where I've been in one room with the parents and I never even see the representative from the district. The mediator goes back and forth between the rooms, kind of communicating for us so that there's not that face-to-face confrontation. The mediator kind of takes the place of the go-between and brings the information back and forth. So it's a little bit different than an ARD, and certainly a little bit more formalized and adversarial. Let's see, so the next one is a state complaint. And I'm kind of dating myself because I used to love Inspector Gadget on Saturday mornings. It was one of my favorite cartoons, and he always seemed to get to the bottom of of whatever issue he was looking into very haphazardly and mostly by mistake, which, now that I think about it, I think sometimes TEA comes to conclusions by mistakes or haphazardly. I shouldn't say that on the record. But this is what reminds me of a state complaint. You are asking a third party to come in and look into the allegations that you're making. So TEA in this scenario would be Inspector Gadget, and they would come in and look into everything that you're alleging happened or didn't happen, and give you a ruling or a report on their findings. Again, if you decide that a state complaint to TEA is the best option for you, I would certainly put, again, as much information as possible, be as specific as possible in your state complaint, provide evidence if possible, but then I would also be sure to include any kind of requested remedies. We'll talk a little bit about what TEA can do as far as remedies in a second, but definitely be as specific as you can about what you want. TEA, again, will pay for the investigator. It's at no cost to a parent to file a state complaint. The 1-year statute of limitations, on one hand, is longer than the 504 complaint, which was 6 months, so that's good. But interestingly, most states across the country have a 2-year statute of limitations. Texas only has 1, meaning if I file a complaint today on April 16th of 2019, I can only complain about something that happened after April 16th, 2018. There is current legislation to change this and change it to the more standard 2 years. So keep your eye out for any kind of information coming out of Austin with our legislative efforts here recently to hopefully open up that statute of limitations to 2 years instead of the 1. Once you file a state complaint with TEA, and I'll tell you how to do that in a second, you have a couple different options. TEA is going to acknowledge that they received your complaint, and in that acknowledgement, they're going to give you an option for what's called an early resolution period. That gives you and the district time to go back and figure something out. And if you can figure something out and come to an agreement, then that state complaint can be withdrawn before they spend the time or effort to look into the allegations that you originally complained about. I go back and forth with that. While I appreciate that that's always an option to reach an agreement, a lot of times if it's something bad enough that I have to file a state complaint, I've probably already tried to resolve it, and that didn't work, and that's why I'm filing the state complaint. But on the other hand, sometimes it takes filing something like this to get the district to realize I'm not kidding around. Like, this is an issue, and if we can't figure out how to fix it, I'm going to get TEA to look into it and tell you how to fix it. So sometimes it just brings a little bit more added emphasis to your allegations rather than just sitting around an ARD meeting talking about it. Also, once you file, you'll still have the option for mediation. So that wouldn't change. You don't lose that option just because you file a state complaint. It would still be voluntary, not mandated. You don't have to do mediation in order to have TEA investigate your claims. TEA has been pretty good in the last maybe 6 to 12 months, especially with my child find complaints, because TEA knows that they messed up with the state cap of special education services. I have had multiple reports from TEA after they do an investigation come back and order a school district to provide an entire school year's worth of compensatory ed services. So I think they're a little bit more amenable to ruling in parents' favors lately regarding child find cases than they have been in the past. That's just my personal experience. For me being the data queen that I am, I have no data to back that up, but I feel like in the last 6 to 12 months, I've gotten more favorable rulings from TEA on child find issues than I have. And TEA is going to give you that written report within 60 calendar days of filing. And I guess what's important to note here too is, let's say that you disagree at ARD and then you go to mediation, but mediation wasn't successful. You didn't come to an agreement. You still have the option to file a state complaint. So it goes both ways. You don't lose your option for mediation if you file a state complaint, and you don't lose your option to file a state complaint if you go to mediation. Okay, so that's kind of something to keep in mind. So what happens when you file a complaint with TEA, you're eligible for individual corrective action as well as systemic. Historically, TEA hasn't been as likely to order systemic corrective action. They always throw one in there that we'll talk about in a second, but they typically focus on individual corrective action. For example, if I file a child find complaint and I say, look, the district should have known that this kid had X, Y, and Z as diagnosed disabilities, and manifestations of those disabilities are seen at school, we need to get them assessed. TEA can order an expedited evaluation, meaning hurry up and get this done because you should have done it earlier. If that student qualifies for services, or if TEA finds that, you know what, Colleen, you're right, the district should have known that they should have been providing PT services all along, TEA can order that the school district go back and provide compensatory education services for the time that they missed. And comp ed services, I'm sure everybody's heard of them. They're kind of an elusive mystery to everybody, I think, but it's not an hour for hour. So it's not my kid missed 2 weeks of physical therapy, so the district owes him 2 weeks of physical therapy. It's a good place to start, but it's not going to be minute for minute, hour for hour, day to day, month to month, what was missed. It's just simply the district trying to make amends for what they missed, and catching that student up on whatever service or support they missed out on during that time. And the good thing about compensatory ed services is that they're all scheduled in conjunction with families. So if you like now we're here we are in the middle of April, if you get awarded compensatory ed services, it's a possibility that you can request those services be provided over the summer months so that your child doesn't have to go to school early or stay later or miss out on any electives or lunch or whatever. You can kind of craft that to work around your schedule and what's best for your kid. Compensatory ed services, though, are hard to sell to teenagers. By age 13 or 14, kids are pretty smart. And when you tell them, congratulations, the district got in trouble by TEA and now you have to go to school more often, that's usually a really hard sell to make with most kids that age. So, but it is dinging the district and TEA saying, hey, you should have been doing this, and now you have to do it to catch them up. ESY services can be ordered by TEA for allegations that are founded. They can order additional assessments be done either through the district or by a community provider. And then they can also, they can't order a specific placement for your kiddo, but what they can say is that they want you to go back to ARD because they feel like the current placement is not the least restrictive environment for your kids. So you'll get some oomph or some push or some guidance if it's a least restrictive environment issue. As far as systemic corrective actions, usually they always throw in there that the district needs to review and revise their policies and procedures regarding the issue complained. So if I make a complaint on child find, TEA might come in and tell the district, hey, look, you might have a problem here with more than just this particular kid. You need to pull all your policies and procedures, review and revise them, send them to us, let us know if you're making any changes, and submit all of that to TEA. They might also mandate that the district provide additional staff development and training. That's why I always say put that in your complaints. If it's an issue about assessment, then retrain everybody on that campus about child find issues and appropriate assessments and evaluations. And then they also might advise a district to use peer-reviewed programming, meaning if a district comes and they're using some fly-by-night system that their social worker created over drinks of wine on a Friday night. Well, that's not going to fly with TEA. It has to be peer-reviewed programming. And so they can guide the district to use something that has already been researched and peer-reviewed. Now, the number one question I always get asked on cases, especially where there's the possibility for compensatory ed services, is there any kind of monetary compensation available? And unfortunately, the answer is no. IDEA as a statute does not give parents at this point in the grievance procedure an option for any kind of monetary compensation, regardless of how egregious the issues are. But I like to kind of remind parents that if you get compensatory ed services for your kid, or if you get systemic corrective action on a district, that costs them money. They've got to find the staffing, the personnel, the trainer. People have to go to these trainings. They've got to bring somebody in to do it, and then they've got to provide the extra services to your kid. So there is some out-of-pocket expense to districts. If you're successful in a TEA complaint, it's just not money going to the aggrieved parent. So I know that can be kind of frustrating sometimes. So if filing a state complaint is an option for you, there's a kind of a quirk on how you have to do that. Prior to filing that with TEA, you have to prove that you've already sent your complaint to the superintendent of the district. So we use fax machines at work, and I know it's 2019 and not everybody uses fax machines, but for me, that's the easiest way to prove that I sent that complaint to the superintendent. My fax receipt record says, successfully sent, and then I take that proof as well as the complaint and I send that on to TEA. So I've provided the mailing address as well as the fax number there. I've never filed one over email. I would probably suggest that you do that in the mail with a return receipt requested, just to ensure that TEA got it, because once they receive that complaint, that's what starts triggering the deadlines for their investigation and for their deadline to issue a report. Okay. So that's kind of the 4 on the left there. I left some time. To me, due process hearings is the good stuff, because that's the most adversarial, it's the most legal, and that's kind of where I think things get interesting. So I left some time to talk about it today, but as Megan and I were kind of talking about the subject of today, I mean, you could And they do 2-day trainings on due process hearings. I mean, they're that complicated and litigious. So we're just going to touch on some of the issues in regards to due process, just in case you are thinking of that as an option after you disagree at ARD. Not that I'm trying to talk you out of it, but I hope that I can convey, if this is an option for you, please, please, please find an attorney to represent you. Because due process hearings are very trial-like. They have opening arguments. You're going to be direct examining and cross-examining witnesses. You're going to have closing arguments. You're going to be entering evidence. It's pretty intense. And it's not a voluntary option in that if both parent and district can request it. If a district requests it, you've got to go. You've got to defend that request for a due process hearing. And same thing, if you file it, the district has to file an answer, and we'll talk about some of these deadlines in a second. But you just can't ignore it. You can't do nothing and sit by and let somebody else look into it for you. This is a very active, litigious process that you'll be involved in. I hope that a due process hearing is really reserved for major issues when there are big disagreements. I definitely would not suggest filing for a due process hearing if you and the district are arguing over, 2 15-minute sessions of physical therapy over the course of an entire school year. Figure out a better way to work that out than going to due process, because it really is burdensome on everybody. But there are a lot of issues where it's very grounded. Least restrictive environment is certainly a very important issue that districts and parents disagree about a lot on. And that really could impact how a kid, perceives every school day and the option that they get or the opportunities that they get to interact with students without disabilities. So that's huge in a kid's life, and that's something that you might want to consider proceeding to that process if you haven't been able to figure it out before then with the district. And in reality, due process hearings, the actual hearings themselves, are very rare in the state of Texas. In 2018, we only had 18 cases statewide actually go to a due process hearing. I don't have the data on how many were actually filed, but my guess is it's a lot more than 18, and they were settled sometime within the process, which we'll talk about in a second, because the state does give you a lot of opportunities to settle this before you actually go to a hearing. And in those 18 cases, it's not good for parents. Parents very rarely prevail at the hearing level, just because in part of the way that the federal law is stated, that, it's a floor of opportunity. Andrew F. helped us a little bit, but it's still not as good. It's not as student favorable as we'd like to see federal and state laws be. And so the parents, if you file a request for due process, you have the burden of proof, meaning you're the one who has to convince the hearing officer or the judge that your allegations are true. And that's really hard. That's a really hard burden to carry walking into a due process hearing for a special education issue. This is similar to the state complaint. There's a 1-year statute of limitations. So you can only look backwards 1 calendar year from the date you file. Now, by the time you get to due process to the actual hearing, if it proceeds that far, you're going to be looking at more than a year, obviously. But what triggers that 1 year is the date that you file your request for the hearing. And then, like I said, that is heard before an administrative hearing officer chosen by TEA, and he or she will act like a judge during the pendency of that proceeding. Once you file a request for a due process hearing, you will get what's called a scheduling order from your assigned hearing officer. And these are just some of the deadlines and requirements that you have as you proceed to the due process hearing. If you file it, the school district has a 10-day response period that they have to acknowledge that they received the complaint or the request for due process hearing. And then they have 15 days to challenge the sufficiency of your complaint, meaning that you alleged enough wrongdoing that it should be heard by a hearing officer. If there's any kind of defect in the pleading or in the complaint, that gives the district time to figure out what that is and to ask the hearing officer to kick it out or make an argument about why that complaint's not enough, why the complaint is insufficient. You'll also get a 15-day early resolution period in where you and the district, you meaning parent, and the district have the opportunity to go to an early resolution session, kind of like an ARD, except not all the usual players at an ARD have to be present in an early resolution session. This is waivable, and I usually waive it because, again, I feel like we've tried that. What difference is it going to make now? But it's still an option for you. The state still gives you an option to try to work things out with the district before you get any farther into this chain of events here, this domino effect. You'll have within 20 days, you'll have a pre-hearing conference, and that'll be over the phone with the hearing officer, the representatives, the district's attorney. Sometimes the special ed director will be on that call, but sometimes it's just their attorney. And it'll be transcribed by a court reporter. There'll also be a court reporter on the phone, and they'll be transcribing everything. At that 20-day pre-hearing conference, the hearing officer will give you deadlines for things like discovery, subpoenas, depositions. You will schedule your actual hearing date. You'll talk about how many days you think you'll need. A lot of times those will be postponed, especially if there are attorneys that have to sync their calendars. If the date for hearing is postponed, then the hearing officer will postpone when their order is due, obviously to let them have enough time to draft that. After that, you'll have a 30-day notification period where you have 30 days to notify the hearing officer if you have in fact settled that case. And you'll also have another option within the first 30 days to go to mediation. Again, that's waivable if you had already tried mediation, or if there's still just so much disagreement and animosity, you just don't think mediation will work. Both parties can waive that. That's not a requirement to proceed to hearing. And then, of course, like I said, you'll get deadlines for discovery and disclosure dates. Disclosure dates are when you have to turn over to the school district's attorney everything you could possibly enter into evidence during the hearing. And that's typically done 5 days before the scheduled hearing. And then you also have to provide the hearing officer a copy. So there's a lot of, obviously, it's no joke. There's a lot of deadlines and requirements and hoops to jump through, and a lot of things happening once you file for a due process hearing, because once again, it is the most adversarial option on that list that I did earlier with the 5 options. So once, let's say you do go to hearing, once you are there and you've entered evidence, you've made your case, you've provided witnesses, you've done your closing arguments, hearing officers can even order what is called closing briefs, meaning that if an issue was brought up in the hearing that the officer wants more information on, they can request that both parties draft and submit briefs on the issue. It's all going to be on court record. You're going to be using the Texas Rules of Evidence and Texas Rules of Civil Procedure. Again, so it's not something to take lighthearted. It's very trial-like, very, very formal, very much litigious. And then, like I said, opening statements, questioning witnesses, things like that. The hearing officer will act like a judge, just like you see on TV. Attorneys will object. They will sustain or overrule objections. They'll enter evidence. They'll deny evidence. So they're kind of like the judge in the hearing. In Texas, what's interesting, and Texas is a little bit different. Most states, you don't have to have an attorney. Let me back up. Most states, you have to have an attorney to go to a due process hearing. You have to be represented by counsel. In the state of Texas, you do not. You can use a lay advocate to represent you, or you can represent yourself at a due process hearing. Again, if this is an option that you're considering, please, please, please get the advice of legal counsel. See if there's somebody you can hire to represent you in a due process hearing, because again, this is not something that you just walk into and wing. It's very formal. It's a very overwhelming process for any parent or any lay advocate to walk into. You've got to know what you're doing. And then if you're curious about, has my school district ever gone to a due process hearing? And if so, for what issues, you can go to TEA's website. They keep data on, I don't know how many years back, but lots of years back. You can search by the year, and then you can scroll down and look by district. You can find your district in a particular year. You can look at the issues that were argued, whether it was behavior, least restrictive environment, independent evals, whatever the issues were will be on the right-hand side of that table. And then when you click on that, you can pull up the actual hearing officer's order or findings. So you'll know when a parent was successful or when a parent was not successful in bringing a particular case or a particular allegation. And they're not fun to look at because, like I said earlier, parents usually don't prevail in due process hearings, but they're there in case you want them. Okay, so let's say you do go through all those deadlines and processes, and you go to a due process hearing, and it's over, and you get your order back from the hearing officer, and you don't like their decision. Either party can appeal an unfavorable decision, but that appeal does go to federal court. You don't go to district court, do not pass go, do not collect $200, you go right to the big boy federal court. And again, that can be super stressful, super overwhelming. Get an attorney if you want to make that appeal who is eligible to practice in the federal court in your district. If you're a prevailing party at the due process hearing, you win, then you can seek attorney's fees from the district from the time you filed the due process hearing request until when you get the hearing decision back. Now, of course, we wouldn't be attorneys if we didn't argue about the meaning of words, so there's a lot of argument out there about what prevailing party really means. For example, if I go to due process on 4 issues and I'm successful on 2, but the district wins on the other 2, am I a prevailing party? Nobody really knows. It's all arguable. So there's been litigation over that, and there's a very subjective measure that they use on how to decide who's the prevailing party. But just keep in the back of your mind that if you are successful at a due process hearing, you might be eligible for attorney's fees, and make sure that your attorney is on the ball and gets that filed quickly. Because we had a case where we waited until the end of the appeal window to see if the district would appeal. And the Fifth Circuit, they took it all the way to the Fifth Circuit saying we waited too long. But we didn't want to file for 2 attorney's fees, one for the hearing and one for any appeal. So even that's been litigated before and is a very sticky situation. So just know that even after you get your decision, there's probably still deadlines that you and your attorney need to follow through with. If this is an option and you want to file a request for a due process hearing, this is how you do it. Same mailing address for TEA, a different fax number, please note that. And just like the TEA state complaint option, you have to file the request for a due process hearing with the superintendent of the district first, and then prove that you did that when you send that request to TEA. And then again, I think I've mentioned it before, same thing as everything else. Be as specific as possible in your allegations. Make sure you request as many specific remedies as possible, both individual and systemic. You basically want to make it as easy for the hearing officer to know what you're complaining about and what kind of resolution you want out of the hearing. So that's really all I had for today. I was told to leave some time for some questions, and so if anybody has any, hopefully I can answer them. But definitely, you know, if you have a specific instance or you're requesting very specific guidance, feel free to email me, call me, do an intake with our office. Our intake specialist statewide, she's really good. Even if we can't do anything to help, we won't leave you hanging. We'll be sure to give you appropriate resources and some other people to contact that might be able to help you.
There we go. I was muted and could not unmute myself. So,
I was pushing the button. Sorry, it took a minute.
That's fine. Well, thank you so much, Colleen. That was really great information. We do have several questions that have come in.
That might be good and that might be bad. Let's see.
If you if you joined late or you didn't hear me before or anything like that, we do the questions for Colleen in this Q&A box down at the bottom of your screen. I know that there's some things going on in the comment box right now. We want to make sure that we don't miss any questions. So if you have a question for Colleen, please, please, please come put it over in the Q&A box so that we can get it answered for you. All right. So first question, I'm trying to go in order here. So we talked about this a little bit at the beginning, but Colleen, do you have anything to add? She has an ARD for a child with a visual impairment. Committee says she doesn't need additional support because she's on track in academics. Do you have anything to suggest or add to that?
No, I think what we talked about before we got started was the importance of requesting the orientation and mobility evaluation, and make that request in writing to the ARD committee. Again, what I talked about earlier, you've got to have that data. If they deny it, get that denial in writing, and then once they deny it, you're free to seek an IEE on that issue. So go to our website, take a look at the IEE information, and request that somebody else do it if they're not going to do it, because they can't make that decision just because they say your child's not, you know, eligible for those services. You've got to have the data to back that statement up.
Sure. Okay, question, and you kind of just answered this, but there's a question that says, what is an IEE?
Oh, sorry. Okay. So we talk in such weird alphabetic soup in this industry, don't we? An IEE is an an independent education evaluation. That basically means that the district's already done some type of assessment or evaluation, and there was something wrong with it. It was flawed. The person doing it wasn't thoroughly trained. They didn't do enough observation sessions. And then you're requesting that the district pay an independent contractor to do another evaluation. And that would come from the community, not from the district. You're basically saying the district had one chance, they blew it, now they got to pay somebody else to do it. And when you request it, there are two options. The district can either agree or they can take you to due process over that request. That's why I say if you're requesting one, be specific why. It can't be that you don't like the physical therapist that did the school district's evaluation. You have to show why it was a flawed evaluation, just in case. It doesn't happen often, but just in case they do take you to due process over that request.
All right. And this is more a comment. It just says, I cannot get the school to respond to questions asked about my grandson, and he has lots of zeros.
Okay. So a couple things. Make sure that as a grandparent, you are allowed to access his school file. FERPA is very specific as to who can be sent information on. So make sure the campus knows that you're eligible to receive information and can contact teachers. If the child is a special education student, call an ARD meeting. Make sure that the teachers that are giving him zeros are invited to the ARD meeting, and ask those teachers to bring work product, meaning you want the teachers to show you why he's getting zeros. Is it incompletion? Is it that things are wrong, things aren't being turned in? Have the discussion, have that discussion on an ARD record, so that it's documented as part of his special education file, and then try to see what services and supports he needs to get those grades up.
All right. And there's a question. It is my understanding that a parent does not have to give reason for an IEE, but hear that you recommend they do so. Is that best practice?
Definitely. And again, that's it's best practice because one of the district's option is to take a parent to a due process hearing over a disputed IEE. So if I have a parent that says, look, you had an occupational therapist do a speech eval, or that usually never happens, but if you identify a reason, the possibility of the district taking you to a due process hearing significantly decreases.
Okay. My son's teacher wants to put him in a TC unit. She says she believes the proper name is total communication.
Okay.
Most restrictive environment. He runs away but is not aggressive. Mm-hmm. I don't think this is the best place for him, but that's the only option they are giving me.
Okay. So again, I would request some behavioral data on they'll probably call it the elopement issue. They make it sound so scary when kids don't want to be in a specified place. How often is that happening? What time of day is that happening? Where does he go to when he leaves the designated area? I would request a functional behavior assessment first, again, to gather the data on what's causing him to run away from a particular situation and not want to stay someplace. And then I would certainly come back and try, see if they'll update a behavior intervention plan that addresses that behavior prior to changing the child's placement. I think that there are probably other things the district should be doing or looking at or attempting before they put him in a very restrictive environment like that.
Sure. Okay. What options are available when the district denies services because the impairment is not severe enough according to their thresholds?
Ooh, so I guess that depends. It's true that just because you have a diagnosis, you're not necessarily eligible for special education services. There has to be a diagnosis and an educational need. Maybe that's what the person is the contributor is talking about. But basically, if there's an educational need, then the school district has to do something to address that need, whether that's through, if they don't rise to the level of requiring special education services, maybe 504 services would be more appropriate, where they're not modifying curriculum, but they're certainly adding supports and services or accommodations for a disability.
All right. Have you had any luck filing for a 504 hearing?
So OCR complaints have gotten very tricky with the new administration. They've been much less likely to look into anything that we have been filing complaints on. We've had much better luck with TEA recently than we have with OCR. OCR takes a longer time than TEA does. They're not as responsive, and they're really, really picky on what they look into. So back in the day, I had a lot of success, and here in the last couple of years, not so much. Most of the time they tell me that they're not going to look into it, unfortunately.
All right. Which process will provide faster and effective results, OCR complaint or formal grievance within the district?
It depends, right? I mean, how many districts do we have in the state? It depends on your district. There are some districts that are very responsive to formal grievances because there are so many deadlines that are triggered when you file that grievance in writing to a district, and there's appeal processes. And so a lot of districts are responsive to that. Lately, I would probably suggest trying the local resolution route first before filing an OCR complaint for a 504 issue, just because of, again, historically compared to the last 2 years, what we've gotten investigated from OCR.
All right. In regards to retaliation, how can a parent formally prove it?
Man, that's tough. And the honest to God answer is I don't know. It's going to be different in every situation. Just like everything else, document, document, document. If you filed some type of complaint on Tuesday and Wednesday, Thursday, Friday, somebody said something or harassed your student each day. I mean, the timeliness to, the easier, the more you can connect it to the time you filed the complaint and about the issue you filed the complaint about, the better. But document, document, document. Who said what? Who did what? Who didn't say something? All of that, write it down and see if you can make those connections for a retaliation complaint. It's tough. It's tough.
All right. Who can we ask to attend an ARD with us?
So that's a question I get a lot. And actually, it's really anybody, as long as the person you're inviting has knowledge and something to contribute to the ARD committee meeting. So you can invite your neighbor down the street if the neighbor down the street knows your child and will facilitate discussions about services and supports for your kiddo. Maybe she, watches him after school and knows what he needs to successfully communicate, let's say. But you can't just, invite your coworker because you're nervous and you think having a friend there will help you feel better. They have to have something to contribute to the meeting and they have to know your kiddo.
All right. Can you give us some examples of when a complaint would be a better option than mediation or due process?
I think it depends on the relationship with the district. I think if you just you're good with the district, but you maybe just want to kick them in the rear end a little bit, mediation might be a good option. It removes some of the players from an ARD committee meeting. So maybe that assistant principal that you're just button heads with in an ARD meeting just needs to get out of the picture, and you need a new fresh set of eyes to kind of help guide the discussions. Mediation would be great. But if you know that there's a big violation and you want TEA's eyeballs on it and you want TEA to ding that district, then that's when the state complaint would be a better option.
Can compensatory services be awarded under Section 504 or only IDEA?
So that's a good question. You can get anything that you agree to. It might not be called compensatory education services, but even short of filing an OCR complaint, if you go to the district and say, hey, look, you should have known that my kid has this diagnosis, it manifests itself at school, and he needs these accommodations, and you didn't do it, and now I want you to catch him up, what's the worst they can do is say no. And if you agree to it, then I guess it is compensatory ed services. But again, that would have to come from an OCR complaint that's been investigated and their issued report. And I just haven't seen many of those recently. So I don't really know what they would order.
Okay. And there was a follow-up question to that, and it just says, if so, what is the process to pursue compensatory services under Section 504?
If you're going to file an OCA complaint, make sure to put it in the complaint, request your individualized remedies as well as your systemic remedies in that complaint. Informally, you can approach the district through a 504 meeting and request those services or supports that you think they should have been providing all along.
All right. In my school district, just finding the forms and procedures for a formal grievance against the district is an ordeal because the school might not provide the rules or forms needed. Mm-hmm. What can parents do to have an expedited access to this option in their school district?
So they're all online. and definitely some districts make them more difficult to find online. But there's a legal framework, and I forget which education service center it's out of. Somebody might know.
Region 18.
Region 18, okay. So you can search by district on that legal framework, and you can search by topic. If you put grievance, it should come up with both the legal policy as well as the policy that they implement, which will state the 10 days that they have triggered once a complaint is filed in writing. They're there, but I understand that sometimes it's harder to find through the district's websites.
Sure. We are going to go ahead and wrap up our recording real quick, and then we can come back and answer some more of these questions, if that's okay with you, Colleen.
Sure.
Right, perfect. Okay, so a few announcements. We do have the TEA collaboration webinar for extended school year coming up. However, we did have to reschedule, and there's a new date on that. So that one's May 21st now at 12:15 Central Time, and then followed immediately in Spanish at 1:15. So if you were saving the date for April 30th, we did move that, and now it is May 21st. All right, coming up in the next few weeks, we are doing multiple webinars. So we have a mother and daughter's journey with autism, and this is part of our Power of Sharing webinar series, and it's going to be done by Dr. Jeanette Reyes and her daughter Michelle, and they're going to come talk about the services that they fought for in the schools, and then how Michelle has managed to transition into adulthood, and they're going to answer your questions and share their story. So make plans to join us. That one is coming up on Monday, April 22nd, again at 12:15 Central Time. Then we're bringing back Miss Colleen Elbe on May 7th at 12:15, and she's going to talk about alternatives to guardianship. So when your child starts to near the age of 18, what can you do? We're going to hear from Colleen on that. And then Tuesday, May 14th, we're going to do another webinar under the Power of Sharing. That's going to be with Araceli Almeida. She's going to talk about her life after high school and how she has transitioned into adulthood and into the work field and things like that. So do make plans to join us for any and all of these webinars if you can. And then you can find a complete list of our webinars on our website as well, which we'll share in the chat box. This is our information. So if you need to get a hold of me, you can email me. If you need to get a hold of Christina, her email is on here as well. You can get on and access the recordings and the PowerPoint handouts from all of our statewide webinars at our website. And then make sure you join us on Facebook. We have a lot of really cool things going on there. And we do a Facebook Live series, and quick little plug. On Thursday at 12:15, I will be going Facebook Live and talking about extended school year services. So if you have questions, make sure you like our page and join me for that.
And also, just as an addition to that, we'll have a Spanish version of that presentation. Margiana will be giving that on Thursday at 1:15.
So do make plans to join us for all of our exciting things coming up. We're going to go ahead and wrap the recording now, and we'll get back to the Q&A portion. Thank you guys for joining us.
Thank you.